welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here today with attorneys Nathan Seltzer and Clayton Calvin. And our director of litigation has finally rejoined us, Chance Weldon.
Welcome back.
We are here to talk today about last week's end of term, last drop of the session, Birthright Citizenship. This is Trump v. Barbara that we're going to talk about today. But before we do, I want to ask you guys something. The 250th was last week, was Saturday. What'd you guys do to celebrate 250 years of our country? Clayton, let's start with you.
Pool party.
Yeah,
What else
seems
do you
appropriate.
think? Yeah, of course.
We had a block party on my block. I invited everyone to my house, my front yard, at 2 p.m. It was like 700 degrees outside. We had a little water slide for the kids, and we sweated and had a great time. It was beat the heat.
That sounds like the most American thing I can imagine.
And you also stood in front of the crowd and you read the Declaration.
And
Did you do that?
Yes, I grilled hamburgers, and when everyone was satisfied, their hunger was satisfied, I read the Declaration. There was 15 kids there, and so I did leave out the grievances, which I think are important, but just for the sake of time. And then everyone got a cupcake.
Yeah.
Red, white, and blue cupcake.
Which is what happened at the Constitutional Convention. At the
Over the water slides and everything. Yeah.
And the cupcakes.
And the cupcakes.
Yeah. Everybody had a cupcake. Mm-hmm. Chance, what about you?
Local parade in our town, and then I mowed the yard.
Perfect.
We also did our local parade. So Belton has the largest parade in Texas. So we got to be among the 30,000 that came to watch Belton's parade. It's the first time we've not been in it, actually. So it was really cool to be like on the outside watching the parade and all of the Americana that comes and convalesces in Central Texas.
Does y'all's parades have water guns? Those kinds of parades? Because those are good parades.
I don't think that has been banned. Candy throwing was banned because a kid ran out in front of traffic and almost died.
That's un-American, though. You can't ban that.
You gotta risk it.
And I just have to expect better parental responsibility, maybe.
I feel like I need to correct. I didn't mow. I weed-eated,
It counts.
Yeah.
It counts. It was a lot of weed eating.
But Clayton didn't celebrate American Independence Day. He clearly celebrated Irish Independence Day.
Yes, yeah.
Clayton and I are both rocking
USA
a lot
is playing
of green
today also, and I should have worn red, white, and blue. I had a hat this morning that I got in my time in England. It had the Union Jack.
That's true. You were wearing a Union Jack today.
Location with that on my head.
But you're not wearing it now, thank you.
No, I took it off. Yeah. And I'm not going to burn it, but maybe I should.
You know what? I don't even know what to say to that. So let's just go right back to where we started, which is Trump versus Barbara. And start at the there's a few things we need to say before we actually get into it. First is just a general reminder. We are a law podcast, not a policy podcast. So we all have our opinions about what citizenship should entail in the United States. But we're not going to talk about that today. You're not going to hear what we think the law should be. You're going to hear what the court says the law is and the different opinions. And we're going to do our very best, I think, to be fair to the court as we go through and steelman their positions as much as possible. So I do think there's a couple takeaways. Chance, you had some takeaways from this opinion as well.
I would just say that anyone there's been a lot of coverage of this opinion, and a lot of the coverage has nothing to do with the opinions that were actually written. I think everybody had already prejudged what their hot take was going to be, and often had a hot take about, for example, the end of the Republic before they'd even read what the opinion said. And I think that, the majority opinion in this case, written by Justice Roberts, it's very short. It's only 20-something pages, and those aren't like 20 pages word processor. It's shorter margins.
Yeah. You could probably read the whole thing in 30 minutes, maybe.
I mean, it's probably not too much to ask before you have a hot take to actually just read the opinions. Yeah. They're really well done. They're thoughtful. And then the other thing, too, is just regardless whether you're super excited about this opinion or you're super upset about it, just remembering that the role of the court is not to decide these policy disputes. It's to decide what the law is. And if you don't like the law, you can change it. If you love the law, you can defend it. But at the end of the day, we're asking the court to decide what the original public meaning is. And there are legal disputes about that. And then also, too, just to remember that the status quo before this opinion was released was that birthright citizenship was the practice in the United States for over 100 years. And so that was the status quo going in. That continues to be the status quo today. And so maybe just pump the brakes on the hot takes a little bit.
On the running around like chickens with our heads cut off, the world is ending kind of mentality. Yeah, absolutely. I think also it's important to, like you mentioned, actually read the opinions before you decide whose team you're on with respect to this. before you decide, yep, I think Justice Thomas got it right as a policy matter, actually read what he has to say about it. Actually read what Justice Roberts has to say about it. Read what Justice Alito has to say about it. So what we're going to do now, I think, is go through the opinions themselves in some level of detail, so that if you don't have time to sit down and read them, you can at least get the 10,000-foot view from us of what each opinion says and where they're actually coming from. So let's start with the majority opinion. I'm sure that if you have clicked on this podcast and you are listening to it, you already know that birthright citizenship was held to mean those who are born in the United States of America, and that those who are born here, even children of illegals or temporary visitors, are deemed to be citizens. That is the majority holding in an opinion authored by Justice John Roberts, Chief Justice John Roberts, and joined by Justices Sotomayor, Kagan, Barrett, and Jackson. Which is a bit of an odd lineup, I think. Not one that we see on the regular. And then concurring in the judgment and dissenting in part is Justice Kavanaugh. And then we have a separate dissent from Justice Thomas. Separate dissent, Justice Thomas joined by Justices Gorsuch and Alito, I believe.
No,
Is it
Gorsuch.
just Gorsuch?
Yeah.
Okay, I'm sorry. Joined by Justice Gorsuch. Justice Alito has his own separate dissent, and Justice Gorsuch has his own separate dissent as well. So we're going to walk through all of those.
It's not a dissent from his other dissent. It's just a separate dissent.
That's true.
Yeah.
He just has
He's
more to
concurring
say.
in his dissent.
Yeah.
He has
concurring
more
with
things.
his own dissent.
Yes. Yeah. Because he, like all of us, has more to say at all times.
Yes. I understand.
So let's start with the majority. And I'm going to kind of walk through a little bit of the opinion, and you guys can interrupt me if I get something wrong, if you have some thoughts. The basis of Justice Roberts' majority opinion very much starts with the text. He very much says, here's what the text says, and then he looks back at history to say, does history confirm what my basic reading of this text is? Which is different, and we'll talk about this when we get there, from how Justice Thomas approaches the text.
Should we start with the text?
Yeah, let's start with the text. The text of the 14th Amendment is, all persons born or naturalized in the United States are and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And this argument comes from an executive order issued by President Trump on his first day in office. The language of that executive order was that children born of persons unlawfully or temporarily present in the United States are not, quote unquote, subject to the jurisdiction of the United States, and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act.
Yeah. The vast majority of discussion around this issue centers on the term, or on the phrase, subject to the jurisdiction thereof, because the rest of the text is so clear. Persons born in the United States, but there's this exception. They have to also be subject to the jurisdiction of the United States, and so we have to determine what that means.
I think it's important to, at this point, to pause and say, this is the text of the 14th Amendment. It is also the text of the Immigration and Nationality Act, like I just said, which is different, but it was a statute passed, essentially codifying, well, the reasons for it are subject to some discussion.
They use the same language.
But it seems to, at least in my mind and according to the majority, to have been codifying the opinion Wong Kim Ark, which we'll get to.
Yeah, and that statute was passed in 1952, for what it's worth.
Yes,
That's a
yes,
little bit
in
later.
the 1950s. So Justice Roberts starts all the way back he starts with the text, and then he goes back to the common law, goes back to the 1500s, and says, back in the feudal England, the law was, if you were born under my jurisdiction, if you were born under the land that I control, you are subject to my protection, and that's what makes you a citizen.
Mm-hmm.
So
The Latin term is it juice soli or
I think
use?
it's juice.
Is a
Juice
soft
soli?
J?
Yeah,
I don't
kind
know.
of like orange juice.
Chance,
or,
you're a law
or
professor.
yogging.
How do you say
Don't
it?
ask me to do Latin. I'm from Texas, y'all.
So I heard Justice Gorsuch at oral argument say juice. So that's what I'm going to say.
that makes sense.
So yeah, it was the common law rule, right of the soil. The idea was, if you are born here, you are one of us. You are entitled to our protection.
Or it's not even so much you are one of us, but I rule over you and you are entitled to my protection.
Yes.
Yeah.
Yeah. You follow my rules, I protect you. That's
It's a
the
relationship
give and
between
take.
the person and the king.
Yes. And he gives an example. Justice Roberts says, a foreign mother could enter the British Isles, give birth, and leave with her child the very next day, and the child would remain a British subject. Why? Because the child owed an implied allegiance to the sovereign who protected him at his birth, no matter how momentary and uncertain his presence in the king's realm. And he quotes Calvin's case, and also a case called Doe, and those are not dated here. I don't have the dates on those. But that is from the English common law. The idea was, even if you are here for one single day, the person who protected you at your birth is the person to whom you owe an allegiance and under whose jurisdiction you're born.
You know, it's kind of funny. I'm sorry. I'll make this a short digression, but I was reading Locke around this subject.
And for those of you who are listening and not watching this, Clayton has Locke open in front of him right now.
But if you are watching, you can see
like a good CAF lawyer.
Like a good CAF lawyer.
And he brings up that situation, and he seems to challenge it. I don't know. Maybe he's just saying that it's a violation of natural law for the sovereign to retain. He said that if you're born in a kingdom and then you leave, you're actually not a subject. Anyway.
Well, it's a direct quote from Justice Roberts, so take it up with Justice Roberts.
Yeah.
But that's kind of where Justice Roberts starts. He starts with that old common law, and then the question becomes, did it change when we came to the United States? And Justice Roberts' answer to that is no, and he supports it with a whole bunch of other writings leading up to not only the Declaration of Independence, but leading up to the ratification of the 14th Amendment. He goes all the way back to Dred Scott and talks about why Dred Scott went the way that it did and how that was a break, because Dred Scott, instead of looking at the Dred Scott decision, was a pre-Civil War decision by Chief Justice Taney, holding that people of the United States are only citizens if they are children of citizens. So it traces back that jus
soli?
Jus soli.
No, the opposite.
Oh, jus sanguinis.
That's the word I can't say.
But Dred Scott is actually an exception that's really created for, in Justice Roberts' telling, for black people.
Yes.
Basically, this was basically Roberts' argument is that it was always jus soli.
Yeah.
And then they create this exception for the children of slaves to make them not citizens. And that's the Dred Scott. That's the blot on American jurisprudence that leads to the Civil War. But Roberts' argument is that was because they were creating an exception from the common law, because of racism.
Mm-hmm.
And that was the firm opinion of the legislature at the time. And so when they then passed the Civil Rights Act of 1866, all of the conversation surrounding the Civil Rights Act of 1866 was in reference to going back to something that had been diverted from, not in reference to, hey, we've been doing this kind of weird thing. Maybe we should change that. Maybe we should codify that. The language of the Civil Rights Act of 1866 is all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby citizens of the United States. And that's the basis from which we get the 14th Amendment, is that Civil Rights Act of 1866. And there's really no question that under that language, those who are born here, including, according to Senator Lyman Trumbull, including the children of Chinese and Gypsies born in this country, that being his exact language, even the infant child of a foreigner born in this land is a citizen under the Civil Rights Act of 1866.
And these are words stated in the debate, the ratification debates? Or?
So some of this is the ratification debates. Some of this is, the language itself from Senator Trumbull that I just read is in the ratification debates. But some of the language that Justice Roberts uses in here comes from opinions from attorneys general at the time.
Okay.
So this is just a whole bunch of swirling law, which is one way to do originalism, I guess, is to look at the swirling law around it to decide what these words mean.
Right.
We can get into this more with, I think, Justice Thomas's opinion kind of makes the distinction between subject to the jurisdiction, like a different take on subject to the jurisdiction. So we get to that, I think it'll kind of draw out more clearly the different takes on that.
Yeah. And this is a lot of what I'm telling you now is more for purposes of setting the stage, because most of what Justice Thomas and Justice Alito and Justice Gorsuch have to say boil down to where they think that the Chief Justice has gone wrong on all of this. So I'm laying out the table here so that hopefully we can have a better discussion in a few minutes. the next question that the Chief Justice answered is, okay, so then what does it mean to be subject to the jurisdiction? Because that's the language that was adopted in the 14th Amendment. He turns to a place that honestly wasn't really discussed, at least in oral arguments, which is Sooner Exchange v. McFadden, discussing generally what jurisdiction means. And you guys can correct me if I'm wrong on this, but I think that's very much how we should do originalism. Is this case that is at the same time as 1968, is it contemporaneous with 1868.
Yeah. That would be bad originalism.
Yeah, that was bad.
That is the opposite of what we're looking for. 1868, this opinion that is using this same exact term and interpreting it in its fullness. Mm-hmm. And he says that jurisdiction means the full and complete power of the nation within its own territories. So the Chief Justice says the limits of... Nope, that's a different section here. Sorry. But the idea was that jurisdiction is, to say that someone is subject to the jurisdiction, it just literally means you're within these territorial boundaries, and therefore you have to follow our rules. And as long as you're born in that context, you're a citizen of the United States.
And that's typically, I think you brought it up, when we're doing originalism with a text, you start with the ordinary meaning or how it was used in other contexts. So jurisdiction means jurisdiction. Can you be subject to the laws?
And like jurisdiction, like we were talking about, like that's like, do you have to obey the law in the place where you are?
Yes.
And then you can
prosecuted, hauled into court, all that.
Yeah.
Yeah, and then you could argue, even as an originalist, you could argue, well, in this case, there's a special different meaning, like that was carried from some prior understanding that departs from that sort of ordinary meaning of the term. But when you do that, you're the one who ordinarily bears that burden, right? Like you start with what the ordinary meaning of that word would be. And then if you want to argue for a sort of bespoke meaning in that particular context, you can as an originalist, but you're typically the one that bears the burden. So Roberts, I think, starts with this was the original meaning of jurisdiction. This is where we would start, but that's not the end of the analysis.
That's not the end of the analysis. And at this point, he says this is... the way that jurisdiction was being used at the time in Schooner's case is a sovereign's jurisdiction makes no exception for those only temporarily present within the sovereign's territory. Instead, nearly everyone within the territorial boundaries of the United States was amenable to the nation's jurisdiction. There's a little jaunt that the Chief Justice does to talk about why Native Americans don't fall into the same category and how the law splits with respect to Native Americans. I don't think it's particularly relevant for our discussion today, but it is an interesting little background information that Native Americans are in a weird category because they are subject to two jurisdictions at the same time.
Yeah, and that was often expressly noted, like in a bunch of constitutional texts and statutes and stuff. It always says excluding Indians not taxed. So, it's clear to see that the sort of default rules were departed from for the Native Americans.
And it's because they maintained for the longest period of time a separate sovereign status with their own territorial jurisdiction that was somehow within the territorial jurisdiction of the United States. As the United States grew and surrounded Indian lands, you would have, for example, the Cherokee still had territorial sovereignty. They still had their own government. They still had their own laws like a foreign nation. And so the Indian tribes are this sort of unique type of sovereignty within the United States that they bend the rules around, for better or worse.
Yeah, but they're an exception to the general rule.
Yeah. Finally, Chief Justice goes on to kick back a little bit at what Justices Alito and Thomas have to say, particularly Justice Thomas. He says less to Justice Alito, but particularly Justice Thomas. And this concept that Justice Thomas raises, and we'll talk more about in a minute, about permanent legal domicile. And to bolster his discussion on this front, the Chief Justice talks about this case, Wong Kim Ark. Chance, will you tell us about Wong Kim? Nope, I'm giving up.
Wong Kim Ark.
Wong Kim Ark.
Yes. By the
and
way,
don't make me say it again.
By the way, some of the justices also said it wrong at oral argument, so you're in good company.
I didn't know that I was given the summary of this case, but I'll do it on the fly. So the basic facts of the case are pretty straightforward. There's a question of citizenship for a child of Chinese nationals. They were Chinese nationals. They were residing in the United States. They were not citizens. They eventually went back to China, as a matter of fact. And then the question becomes whether or not Wong Kim Ark is, in fact, an American citizen because he was born here to these Chinese nationals while they were present in the United States.
And they were lawfully present.
They were lawfully
some
present.
Of the justices point out.
Yeah.
But modern immigration law doesn't exist really at that time. And so whenever he returns, the question is whether or not he's a United States citizen. The court says that he is, because he was born in the United States and therefore subject to the jurisdiction thereof at the time. And that's it.
It's a pretty simple case, actually.
They used Robert's rationale description of subject to the jurisdiction.
Yes, they do use Justice Roberts' description of jurisdiction.
It's a very long case, and it says, so there's a lot of explanation, and that's why people are arguing over it. But the main holding of the case is that the parents were here lawfully, therefore their child who was born here was subject to the jurisdiction of the United States. They don't use that language in the case, in the holding. They never became naturalized citizens, though, and they eventually returned to China. But because he was born here when they were here lawfully, then their son is an American citizen by birth.
Right. And that's the ultimate holding of the court, independent of their intent to remain or any of those other things that some of the other opinions think are important.
Yeah, I think the justices have a lot of discussion and dispute and back and forth about like the extent of the holding. We can get into this later, but the extent of the holding of Wong Kim Ark, does that holding only apply to facts that are identical to those in that case where the parents were here lawfully, or does the rationale used to resolve that case apply in other situations also, because the same rationale can be applied, and which I think is not typically how we think of holdings.
Yeah.
But so
the government made the argument that because the subject of the jurisdiction part wasn't like explicitly argued, that you could basically, that this supported their position just as much as it supported what ultimately the holding of the court is, that that he was here lawfully. If the parents had been here unlawfully, then he would not have been a citizen. It would be a different case.
Yeah.
So he's here lawfully, whereas illegal immigrants are here unlawfully, so they can't be subject to the jurisdiction in the same way that that's like you and I are.
Yeah. But the majority thinks that Wong Kim Ark applies.
Right.
Here.
The majority thinks that Wong Kim Ark, for all intents and purposes, is controlling. They would view any attempt to change the outcome of Wong Kim Ark or to limit the outcome of it would be overruling it. That Wong Kim Ark on this front at least is completely controlling. And I think the majority makes the point that there is nothing in Wong Kim Ark that would imply that it would change if they were not here lawfully. Like, it's mentioned, but it's not mentioned in a contingent sort of basis. So
And
I want to
and also they can't cabin Wong Kim Ark to its facts without sort of de facto overruling the rationale.
Right. There's no way to cabin Wong Kim Ark. There just isn't, at least according to the majority.
So and this is like an 1898 decision, so we're like 30 years
We are
past.
after the fact. And in a minute, I want to circle back to something very strange that the Chief Justice says with respect to that. But I do want to read his last point. His last point is just in 2 quick little paragraphs. I want to read them verbatim because I think they're very interesting. If Congress intended to limit American citizenship to the children of those domiciled in the United States, nothing in the succinct language of the Citizenship Clause conveyed that design. Words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. For a simple reason, they did not matter. And while the clause does ensure state citizenship attaches for U.S. citizens in the state where they reside, the explicit invocation of residence for state citizenship only highlights its absence from criteria for U.S. citizenship.
Mm-hmm.
Where the dissent sees feudalism, the framers of the 14th Amendment saw emancipation. By the time of the Glorious Revolution of 1688, in fact, the tie created by birth was less a duty than a right, the foundation of the ancient liberties of freeborn subjects. That is why Blackstone describes the privileges owed to the natural born. That is why colonists demanded the rights of Englishmen more than 250 years ago. And that is why abolitionists lauded the ancient and universal rule of citizenship by birth alone as an ordinance of heaven. Citizenship, then and now, was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended the promise to every freeborn person of this land. We keep that promise today. The judgment of the District Court for the District of New Hampshire is affirmed. So that last point that he makes is, if they wanted to say mother, father, domicile, temporary, visitor, any of these things, they knew how to say those words. Those words existed back then, but the drafters of the 14th Amendment chose not to. And we can assume from the fact that they are not there that they didn't intend to use them.
There's a Latin word for that too. The absence of one thing, like you can infer that it's deliberate when you read another text and it's absent. because there's also, and I think you might talk about this in a little bit, but there's the Contemporaneous Civil Rights Act of 1868, and they
1866.
1866, yeah.
And they use the statutory language there is and not subject to any foreign power, rather than and not subject to the jurisdiction thereof, or
and subject to the jurisdiction thereof. Yeah.
And so the argument is, so some of the dissenting justices say, hey, excuse me.
They also knew how to use that term.
This is, well, no, they say, well, this is a concurrent statute, so it must inform us as to the meaning of the 14th Amendment. But the majority would say, well, they had those words available to them and they didn't use them. So that means it probably cuts the other way, in the other direction.
And it's important to think about, like, there's nothing unusual about this mode of analysis, this sort of application of the canons. Or if you've been watching the podcast for any length of time, you've heard us talk about the canons of construction and how originalists apply them to the text. And if they use the word somewhere else and they don't use it here, the assumption is, well, they knew how to use it and then they didn't use it here, so that means they didn't intend to. And so just when you read it, and this is why I always encourage folks to read the opinions as opposed to just listening to commentators.
Although we encourage that too.
Yes.
If we are the commentators.
Right? Please do continue to listen to us.
Please continue to listen to our podcast.
Just us. Only us.
Yeah. But look at the text. I mean, and they're doing ordinary sort of textual analysis, and you can agree with it or disagree with it. And certainly, the dissents we'll talk about in a second do disagree with their application of the text, but it's not like they're making a policy call here.
Yeah.
They're just doing the same stuff that the court always does.
And before we turn away from Chief Justice Roberts' opinion, there's a sentence in here that my brain screeched to a halt when I read it, and I want to know what you guys think about it. He says, in any case, post-enactment history cannot override the text. As originalists, how does that hit you? And does that strike some fear in the back of your mind?
I would be careful about that. I think that's taken on its face. It's true. If they did something that was completely contrary to the text, then you would say that doesn't override the text.
Act.
Exactly. Yeah. Perfect example.
Right.
So they can't do the Alien Sedition Act did not override the First Amendment.
It doesn't even inform our understanding of the First Amendment.
Right. But sometimes if everyone agreed that a post-enactment act of Congress or something does comply with the text and it was undisputed at the time or lightly disputed at the time, then that might inform our understanding of it. So that's principles called liquidation, that we're looking at the cases, that follow whatever that statutory text is to determine what that meant. That's not really what happened with Wong Kim Ark, because it's long enough after, we're at 30 years after, that's not a very good.
Yeah, and there's an interesting question that I'm sure Chance can probably answer right now, but is originalism, does that mean that you look to, specifically when there's ambiguity in the text, you look to the surrounding original public meaning to inform that ambiguity? But what do you do when there's not so much ambiguity? You should still look you should be informed by the context, but to a lesser degree.
Well, you're always going to be looking to figure out the original public meaning because language changes over time. As anyone who's read an original King James Bible, for example, language changes over time. And so what you're trying to get is what these words meant at that time. And so context is always going to inform that. The question becomes
regardless of whether it's ambiguous.
Yeah, regardless, because in order to determine whether or not it's ambiguous, you have to look and see if there are competing meanings at that time period.
Yeah.
Because that's the meaning that you're trying to ascertain. I think where the debate has kind of crystallized at the court right now is how much post-ratification history informs the original public meaning of the text through liquidation. How far post-ratification do you get to look? How much do post-ratification treatises or laws inform what we think the original meaning of the text are, as opposed to pre-ratification documents? And what he's saying here, again, on its face is correct. Post-ratification history can't override the plain meaning of the text. Though I do think that in the text history and tradition approach that the court's been applying, some early post-ratification history can help inform the meaning of the text. But I think as a statement, just taken on its face, I think he's correct that post-ratification history doesn't override the meaning of the text.
But it'd be very easy to take that narrow thing that he's saying and draw a big principle of it, which is we don't care, in a case immediately following it, we just not care about that at all. And that's not really true either.
Yeah. Kind of a judgment call. It's how clear is the text and what does the context tell us?
Yeah. Well, and I think that word, that overriding, is carrying a lot of water
right
there. he's saying very specifically, he's not saying it doesn't inform, he's saying it doesn't change the meaning of the text.
Yeah, good. That's a good
And
distinction.
that's that. I mean, it's not exactly the same as saying like this. I guess again, the good example of this is the Alien and Sedition Act, where if you were to read the First Amendment and assume that the Alien and Sedition Act is what the First Amendment means because it is so close in time, you would be overwriting the text with
right, because you would also have to
language of the.
You would also have to ignore all of the people at the time the Alien Sedition Act was adopted that thought it was unconstitutional.
This is unconstitutional. Stop it.
Including
Yes.
the President of the United States, Thomas Jefferson.
Yeah. All right, so let's move on. First, I just very briefly want to touch on Justice Jackson's concurrence. I don't think we need to spend a whole lot of time on it because I don't think she intended for this to be a majority opinion. She comes in with a history lesson talking about the importance of citizenship specifically to Black Americans and talking about how citizenship has evolved with respect to Black Americans. And it is an interesting read, especially as far as history lessons go, but not, I think, particularly important from a legal standpoint.
I mean, she does get on her hobby horse that she's had, that the 14th Amendment does not create a colorblind constitution, and I think we've disagreed with her on that premise before, but she uses this to throw a little bit of shade at Justice Thomas and the rest of the court, because we'll talk about in a minute, Justice Thomas talks about the citizenship provision being just for freed slaves.
Right.
And she says, I thought the 14th Amendment creates a colorblind. Yeah.
And I think she means it. I mean,
she means it, but she applies that outside of this context as well. And I think whether or not that's a fair critique of Justice Thomas's opinion, I leave to the folks here to decide for themselves. But it is interesting that she has been beating this hobby horse every time that she gets an opportunity to, whether that be in the affirmative action context or other context as well. That's sort of a hobby horse that she has.
Yeah.
She says, even though the original context involved, freeing, making sure that African Americans had citizenship, she says that doesn't mean that you limit it to it. She uses the analogy of if there's a teacher and she tells a kid not to bully somebody in the class, the instruction isn't to stop bullying that specific child. It's like, no, stop bullying.
Being a bully.
Yeah, generally.
It is interesting that she would have a colorblind view of the citizenship
clause.
She's
kind of changing her position there.
And then she doesn't have a colorblind view of the equal protection clause, which...
Right. Interesting.
We all get there somehow. Okay, so let's move on to Justice Kavanaugh's opinion. Chance, tell me about Justice Kavanaugh's opinion.
So... there are really two parts to Justice Kavanaugh's opinion. I'll start with the first one because I really thought going into this case that the first part of Justice Kavanaugh's opinion is where the court would probably end up 9-0.
Yeah, solidly. We don't even need to get to the constitutional issue.
Yeah, and so what Justice Kavanaugh argues...
I think we were all surprised by that when they came down as a constitutional opinion rather than...
Let him say surprised by what, though?
Justice Kavanaugh argues that you don't have to reach and you shouldn't reach the constitutional issues here because this can be resolved on statutory grounds.
Because who has power over...
Congress.
Yeah.
Right? Because Congress, under the Constitution, has power over immigration and naturalization, and they write immigration statutes. And the immigration statute from the 1950s, and I'll get to why he believes this, he believes that it guaranteed birthright citizenship, and therefore the president can't unilaterally change immigration law. Now, this should sound very familiar to anyone who listened to us talk about tariffs or environmental statutes or anything that we've talked about on this podcast for a long time, that the executive branch enforces the laws. It doesn't write the laws. Congress writes the laws. And that the president can't just unilaterally change a law that Congress has written. Conservatives we used to believe in these things. Whenever
so much shade.
Whenever Obama, for example, did DAPA and DACA and tried to, he said, I have a pen and I have a phone, and he was going to circumvent Congress to rewrite immigration law. A lot of conservative groups, a lot of conservative states, including Texas, sued over that the president doesn't have the right to unilaterally change immigration law. And Justice Kavanaugh makes this argument here that regardless of what subject to the jurisdiction thereof meant in 1868, by the time Congress wrote the immigration statutes in the 1950s,
specifically the Immigration Nationality Act that we talked about earlier,
the overwhelming understanding of that language post Wong Kim Ark was that it granted birthright citizenship. And if you actually look at the other parts of the statute that talks about what the presumption is when you find a child without parents, or the presumption is that children born in the United States are citizens of the United States, full stop. And therefore, he says, this is an easy case. We don't have to answer these tough constitutional questions. We can decide this based on the statute. And under the doctrine of constitutional avoidance, if it's not necessary to reach the constitutional question, the court shouldn't reach out to decide that constitutional question.
Yeah, and that's a long-standing doctrine that the court uses all the time, but they didn't use it here.
Yeah, but what the government argued, what the Solicitor General argued, was that this older sorry, I lost my train of thought. The statutory argument couldn't ossify, is what he said. It couldn't create a new meaning because they use the exact same language as the 14th Amendment.
Yeah.
And so whatever the 14th Amendment means is at the time of the founding, at the time it was written, that's the same meaning. So it couldn't have changed over time. That's what
you
the
assume that
SG
they
argued.
intended to incorporate that.
Yeah.
That's the meaning of it.
Yeah. So I think this is a really difficult legal question because you have two competing canons, right? Not canon kaboom like a gun, but canon like rules of interpretation when you're looking at a legal text. So the first, typically we have this rule that says whenever you use a term in one place and use the same term elsewhere, it carries the same meaning. There's a great line that says, we assume that it carries the old soil with it, right? So basically, if they use subject to the jurisdiction thereof in the Constitution, and then Congress uses subject to the jurisdiction thereof, we assume they carry the same meaning. But where this gets complicated is where you have an intervening Supreme Court opinion that says the meaning of subject to the jurisdiction is this. Does it carry that meaning? Do we assume that Congress knows about the Supreme Court decision and is copying their interpretation of the constitutional text? Or do we assume that Congress is invoking the original public meaning despite what the Supreme Court has said?
Right. The question is, which soil does it bring with it? Does it bring with it the original public meaning soil, or does it bring with it the gloss that was put on it by the Supreme Court?
And there are other canons that say that we presume that the legislature knows about the intervening. There's actually canons that say that.
There are canons that say this. And so what Justice Kavanaugh argues is that unless they expressly indicate otherwise, they're adopting the Supreme Court's interpretation. We assume that Congress, it knows how to say, hey, we think the Supreme Court is wrong. It does that all the time. And it could have clarified and it didn't. And so absent some sort of clear statement, we're not going to assume that they've changed the law in some way. And again, this should sound familiar to everyone that's heard us talk about the major questions doctrine and hiding elephants in mouse holes, and do we require a clear statement when you're departing from the status quo? And Kavanaugh's just applying that same standard here. And he says, absent some sort of clear indication that they wanted to have some different meaning than what the court had said in Wong Kim Ark.
In spite of what has been said in previous Supreme Court decisions, something along those lines.
Yeah. And so in that case, the executive order is unlawful because it just departs from what the immigration statute was.
Although it still makes it necessary to determine the scope of Wong Kim Ark. We don't get out of that.
It does a little bit, right?
Yeah.
It does. You have to determine what the understanding of that case was in the 1950s.
Yeah.
Right, is what he would say.
Which is a little bit different.
Which is a little bit different than what
itself.
the case actually said. It's like, what was Congress's understanding of that case?
This job's too hard.
You don't have to. You don't have to reach the constitutional question, though.
Yeah.
Which is why it narrows it, and then we would still, if Justice Kavanaugh's view had prevailed, we would still not know, at least as a matter of official doctrine, whether or not the 14th Amendment gave birthright citizenship to.
Which is kind of okay.
Right.
I mean, answer the question that's squarely in front of you without going to the constitutional question is what the court does.
And honestly, I thought that's what the court was going to do here. It's a very Justice Roberts. Justice Roberts has said before, if it's not necessary to decide more, it's necessary to not decide more. That's like a quote from Justice Roberts.
The author of this opinion.
And so I thought...
The one who just decided more.
And also Justice Roberts historically has tried to cobble together where he can very narrow, unanimous opinions on contentious issues. And I think because he believes that that's sort of an important social dynamic for the court. Now,
it'd be right up his alley to get everybody on board with statutory.
Sometimes I disagree with that approach, but it's definitely a Justice Roberts thing. So I thought going into this argument that that's what the court was going to do, but then there was no questions.
There were very few questions about
the statute. And so at that point I was like, oh, they're doing something different.
I wonder, and this is complete speculation, but I mean, why they might have done that. Maybe they thought that this is such a hot button issue that if they only decided on statutory grounds, then Congress would change it.
Yeah.
And then the question could come, then the actual constitutional question would come back before the court a few years later. And there'd be all these resources and rigmarole along the way that could just be avoided by, like, if we all think the Constitution means this, then we'll just say no.
That's pragmatic, though. That's not.
Yeah, it's not a doctrinal method. Like,
and what's weird to me is that none of the other justices even mentioned this. Like, there is this glaring issue of, but an executive order can't override a statute. And the other justices are just like, well, it can be whatever it wants to be. That's fine.
There was a little colloquy on this at oral argument, and they specifically, from Justice Gorsuch, asked, could we, do you think there's any daylight between what the statute says and what the Constitution says?
Yeah.
And the Solicitor General said, no, they mean the same thing. In fact, it's impossible for them to mean different things because Congress used the same language. And so if that's true, then he made it very hard for them to come down with a statutory decision here. Because it's almost comes up with a party presentation rule.
But they're not bound by what the Solicitor General says the statute means. They tell the Solicitor General he's wrong about the statute in all of the major questions doctrine cases. That's,
all the time.
Yeah. But he basically said we're not arguing.
But the plaintiffs in this case said that it was also outside of the statute. So you don't have a party presentation rule problem. Because the plaintiffs in this case were arguing that the statute forbid this.
That's what a lot of the amicus brief centered on too, if I recall. This was a legitimate argument that was raised by the parties and supported by amicus. So I don't know.
Court totally could have taken
it. It's weird that the majority in particular says absolutely nothing about it.
It's also funny though that Justice Kavanaugh, even himself, after he makes this point, goes on to say, but I also think that the Constitution doesn't forbid this and Congress could do this if it wanted to, which is a weird.
And there's the second point. There's your second point.
It's like you're trying to avoid it and then you just avoid it.
But it's a concurrence, and so it's
he can say that.
He can wax a little bit more eloquent.
That's why we like concurrences.
But I mean, if you're really going to make a big deal about, hey, the court shouldn't reach out to slay dragons that it doesn't need to slay, you probably shouldn't go start slaying those dragons.
Although it does serve, in a certain way, to be fair, to say the other side, it does sort of serve to draw the contrast between Congress, the Constitution says what citizenship must mean, Congress says what it may mean, and there's.
Is there a little bit of et tu, Brute here? He's like, well, if they're going to decide the Constitution, I'll put my sword in the dragon also. Dragon's already dead. I'm not going to be against that.
Yeah.
I guess we might as well all weigh in on this. So,
I mean, almost everyone does. I think
everybody does.
There are 5 separate opinions.
Oh, yeah. Kagan.
Yes, I think Kagan and Sotomayor do not have their own opinions, but everybody else has something to say. And Barrett,
does not. Yeah.
So 5 opinions. 6 opinions? 6 opinions.
There's 6.
Yep.
It's 205 pages, I think, of opinion. Oh my goodness.
We've gotten to 2 of them.
And we've gotten to 2 of them, and we have 10 minutes left. So to talk about the longest opinion, Nathan, give us Justice Thomas's perspective on all of this as quickly as you can while still being accurate.
Yeah, so he only wrote 89 pages. I'm just going to read it real fast.
Yeah, you can go through it.
But Justice Thomas is basically saying that everything hinges on the subject to the jurisdiction thereof, and that hinges on domicile. So whether or not the person was legally domiciled in the country, it determines whether or not they're subject to the jurisdiction thereof. And to get there, and Clayton alluded to this earlier, to get there, he goes to the Civil Rights Act of 1866, which used different language. And it said not subject to any foreign power. And so when we changed that language from 1866 to 1868, and he makes the argument that it's generally accepted that those two things had the same meaning, and that what they were doing was trying to clear up the Indians not taxed part and to clean up the language just to make it more concise for the 14th Amendment. There's some disagreement on that point, clearly, but that would be his argument. So not subject to any foreign power sounds a lot more like that we're not just looking at whether or not you have to obey the laws of the United States, but we're looking at whether you would owe allegiance to a different country, and that's kind of looking at your citizenship and things like that. Right. So he's saying that all hinges on domicile, which is where you legally reside for the purposes of assessing citizenship, but also who can tax you, who can control your movement, and all these kind of things.
So that's interesting. He suggests that domicile is going to determine where your allegiance might be.
Yeah, absolutely.
Yeah, and well, it's important that you added a word there, like where you legally reside. He doesn't actually reach, and Gorsuch talks about this in his separate, even though he joins Justice Thomas, Justice Thomas, even in a footnote, points out that he's not saying the domicile would not apply to illegal aliens. He leaves, Justice Thomas's opinion leaves open the question of whether or not an illegal alien who's lived here for a decade and has a child and intends to remain, that child would be a citizen. Like Justice Thomas doesn't reach that question. You want to explain why not?
I think that well, first of all, you're reading for 89 pages. You expect him to get there at some point.
Yeah.
But I think he just says it doesn't matter, because if we're looking at the person's domicile, that they're domiciled here, or they're not domiciled here because they're not legally present. And that's the argument that the government made also, is that in order for you to have a legal domicile here, you would have to be legally present here. And I think Justice Thomas would say that they're not legally present here. Do you disagree?
No, I disagree. He has that whole footnote where he says we don't reach that question because it's a facial challenge, and it's a facial challenge to the entire executive order.
That footnote is from Gorsuch, right? Is that the one you're talking about?
No. Gorsuch has a whole separate
He has a whole separate concurrence.
But Justice Thomas himself, in his opinion, says there's disagreement about whether illegal alien domicile, like domicile requires you to be lawfully present or not. And then he gives a sort of hat tip to Gorsuch in the footnote, and then says, but we don't have to resolve that because this is a facial challenge.
Wait, so can you have a question? Can you have a domicile if you are illegally present? Or no?
Justice Thomas doesn't reach that one.
That's what's
he doesn't reach
open.
that.
But where it really applies is with the temporary visitors, like the birthright, the birthright citizenship tourism that people are engaging in. Because clearly, if someone just comes here just for say they come here for 1 month just to have a baby,
right,
then that person has their domicile is not in the United States. They're from China, or they're from Ukraine, or wherever, and so their child under that theory that would always be domiciled in their country of origin. And so they would not, and certainly the parent would be domiciled in the country of origin. So then the child would not be subject to the jurisdiction thereof, if it means the same thing that Justice Thomas says it means, which is the same thing as not subject to any foreign power. So the real question is, does it mean that not subject to any foreign power, or does it mean subject to the regulatory I have to obey the laws here?
Yeah.
Interesting.
I think it's interesting to point out that Chief Justice Roberts here does a side swipe at Justice Thomas for this on originalism, right? He out originalists the foremost originalist. He says the only evidence that the government and the principal dissent, that is Thomas's dissent, can muster to show that some alternative, in brackets and in quotes, primary conception of allegiance displaced the common law is a quote-unquote funeral oration for President Lincoln. Ahistorical modifiers aside, the government and the dissent identify no source that defined allegiance at birth as being based on domicile in the period from 1776 to 1868. And then in the footnote he says the principal dissent comes closest with the decision of New York's Intermediate Appellate Court in Ludlam v. Ludlam, which is an 1860 case. When New York's highest court heard the case, however, it did not follow the lower court's reasoning. It relied instead on Lynch v. Clark, which is a case that he discusses at great length. So it's interesting to me that Justice Roberts says, look, you say you're being an originalist, but you can't identify a single original source other than a funeral oration for President Lincoln that actually uses this term allegiance to mean what you want it to mean.
I think Justice Thomas's answer to that is in his opinion, and he basically is saying, well, look at ambassadors who are visiting this country. Look at there are exceptions where people are born on American soil to foreigners and they're not given citizenship. And I think Roberts' shot has its best teeth when he's talking about, well, those are exceptions to the rule. There's not a specific exception for temporary foreign visitors, and of course we have the idea that people were concerned that they were going to give gypsy citizenship and things like this at the time of, and I'm using the language from
Romani's.
So I think, but what Justice Thomas would say is, well, how could we make exceptions for ambassadors but not for temporary foreign visitors of other stripes? And I think there's some merit to that.
Yeah, I mean, Justice Roberts' answer was that there's a fiction of extraterritoriality that comes with being an ambassador that goes back to the common law.
Yeah. And then
And then
that brings us
to Justice Gorsuch, who narrows a little bit, I think.
Did we already talk about it? Are we going to talk about Alito?
Gotta do Gorsuch first.
Let's do Gorsuch first.
Alito came first, but Gorsuch is just kind of piggybacking off of
yes.
Thomas.
Let's start with Gorsuch.
He joined Thomas, and then he just wrote separately to say, I agree with everything that Thomas said. But there are just 2 points that he wanted to make. One was basically making sure that he clarified that Thomas's dissent and his dissent were compatible with Wong Kim Ark, because Wong Kim Ark is, the holding of that case is, as we treat all holdings, based on the facts of that case, and the parents actually were domiciled, so that nothing about that disproves or is incompatible with his and Thomas's dissent. And then he did something that we, as public interest lawyers, just really found shocking.
Don't talk about that.
And completely, but it's so important.
I know.
And completely potentially unnecessary. It's not unnecessary. It's procedurally part of the case. But he said that facial challenges are usually denied. So this was a facial challenge, just saying the EO is just unconstitutional, period.
Real quick. So a facial challenge means the whole executive order is unconstitutional and you just have to get rid of it
on its face.
In terms of how you apply it.
It can't be applied constitutionally.
Can never be applied.
Yeah. And an as-applied challenge is when you say, okay, this government action might be constitutional in some context, but as applied to me, it's not constitutional. And so he's saying that because this is a facial challenge, we're not going to strike down this EO, this executive order, unless all of its applications are unconstitutional. And he says because of this domicile theory that at least some of the EO would be constitutional, and so the plaintiff should lose. But that has a very broad ripple effect for plaintiffs everywhere who want to challenge the government.
Because it's interesting, because Gorsuch actually says in his opinion, hey, there's some tough constitutional questions about whether or not, this domicile theory would exclude illegal alien children, the children of illegal aliens that
he said he harbored doubts about the government's argument.
But because the EO also applies to birth tourists, and he thinks that you could constitutionally exclude birth tourists, that he's not going to say that the EO is unconstitutional because you chose to bring a facial challenge.
And therefore he doesn't have to decide that legal issue because it's not necessary to resolving the case.
Yeah, because if it's constitutional in one application, then it's facially constitutional, even if it's unconstitutional in all the other applications.
And this has been, we made this observation, an ongoing project is probably not the right word, but it has been gaining traction particularly in conservative legal spheres, that facial challenge means that it is unconstitutional in every single conceivable application, not even just every application that we can identify, but those not just that we can identify, but those that we can conceive of. At some point, you get to a place where it's, there's no such thing as a facial challenge anymore. Every challenge must be as applied.
And everyone has to bring their own
Everyone
claim.
has to bring their own claim. And just to point of personal privilege, veer off into policy a little bit, that's really dangerous territory. It is dangerous to say, it's very costly. It's dangerous to say that every person who is injured by something that is unconstitutional in 99.99999% or even 100% of all of its proven applications, every single individual must sue to vindicate their own rights.
The people have to play a large game of whack-a-mole against the government.
Yes.
Yeah.
And at no point can a statute ever be struck down as unconstitutional if there is a conceivable application of it. And you get into the place where you're not even really bound by rationality anymore.
Yeah. In fairness, he doesn't go that far. He just kind of says the general Supreme Court rule.
He does just quote the general Supreme Court rule. And
but his implication, though, while he's talking about, I can see that this big, large swath of the population, this would be unconstitutional for, but this little tiny side problem.
I don't know if it's little tiny, because there's the children of birthright tourists, and then there's the children of illegally domiciled people, and the executive order kind of targets both of the. I don't know which group is bigger, but they're both big chunks of the executive order. So it's
probably
more
people are affected by illegal immigration than birth.
His critique would be just, in that case, bring an as-applied claim.
Yeah.
Right.
Yeah.
And I think the concern from the sort of public interest side is.
Well, let me get, so the alternative to what Justice Gorsuch, what he articulated here, is that if the statute has an incorrect standard, if it's applying a standard that would not be constitutional, then it's facially unconstitutional.
Yeah.
And so we can just look at the standard and whether or not that's constitutional, rather than look at every possible application of that standard. But go ahead. Yeah. So.
No, I think that the real critique is just one that's sort of pragmatic, which is, I think there's a lot of norms that if the court holds a statute to be unconstitutional in most of its applications, the executive branch will just stop enforcing that statute. It won't try and pick out little vestigial pockets where it can keep enforcing, because that's just kind of been the common practice. But there is a fear that if you have an executive branch that doesn't act in good faith, that continues to enforce, that there's a problem. I mean, a great example from our cases was the short-term rental litigation in Austin, where we won a case holding that the City of Austin's short-term rental ordinance was unconstitutional. And the city came back and said, well, that only applies to your plaintiffs. And so they continued to enforce their short-term rental ordinance for 2 years against everyone else, until other people came back and sued, and other people came back and sued. And finally, a federal court was like, hey, I'm pretty sure the court has said that this ordinance is unconstitutional. You should stop applying it. So if you don't have a government that acts in good faith, then you can have some problems. But I think built into this sort of facial as applied distinction is this idea that that's going to be the small tail of the distribution where the government behaves that way.
At least that's the hope. But I mean, we are a republic built on skepticism. We don't typically operate under the assumption that the other branches are going to operate in good faith, and so.
Yeah.
And this is kind of like the idea.
We're pitting ambition against ambition.
Yeah. And this is the contrast between like universal relief and relief that just runs to the plaintiffs. It's a similar idea that if you're similarly situated to someone who just won a case, you should get some relief from that, even like in an as applied challenge, if you're like just like the person that just won. And so the court's narrowing that also. And so there could be a problem that could arise where if the court narrows relief so much that winning a Supreme Court case might help you, but it doesn't help anyone else.
Can I steel man the other side for just 2 seconds though?
Yeah.
Because we have been talking about earlier about like not deciding issues that you're not required to decide. We all just reasonably
right.
If you're not required to decide it, to decide.
Don't go to the constitutional issue.
And there's a certain element of the role of the court under Article 3 is to resolve controversies between the parties. And so if it's not necessary for me to reach this sort of facial issue about the Constitution and all of its other applications to resolve this case, then do I as a judge have an obligation to not decide the facial question if there's an as-applied
Well, there
way
are
to resolve
prudential reasons not to. I don't know if you have an obligation.
But I think looking at other applications that could demonstrate a problem, but if you're looking at the standard that the statute applies, that's really just this case. You're just looking at is this a good standard?
I guess my bigger grievance is that there's a sort of switcheroo that happens where it's like, oh, you brought a facial claim, so I'm not going to adjudicate your as applied.
Right, which is insane because if I'm saying it's facially unconstitutional, then by definition I'm saying it's unconstitutional as applied to me.
Yeah, and so there's a little bit of we should probably just assume all facial claims
include
as applied claims.
Yeah. So let's quickly get to Justice Alito's dissent.
So he's got a spicy, as I've heard him called before, spicy Alito.
Spicy Alito.
So he has his own individual dissent as well, and he is slightly different from Thomas and Gorsuch's dissent, and that he really focuses on allegiance more than just domicile. The other two kind of use domicile as maybe like a proxy for allegiance, or the allegiance is like a part of domicile, but Alito really focuses on allegiance. And again, he uses this contemporaneous civil rights statute that talks about not subject to any foreign power as evidence for this belief. He refers to Wong Kim Ark as a sprawling and imprecise 19th century opinion that shouldn't control this precise question. And then he gives a lot of like practical concerns and arguments that talks about birth tourism. We're one of the few countries, few affluent countries who have this rule in our Constitution. Although I looked it up, and it's actually not so much of a affluent versus non-affluent country divide. It's like an old world versus new world thing. Most of the countries in the Americas have birthright citizenship, and most of the countries in the old world don't, which makes sense given our history, and a lot of people came over here, and the old world, that's not true.
Yeah, how many of them were based on the English common law? I mean, at least us in Canada.
Well, separate from that. Yeah,
separate from that. Yeah.
And then he delves into the history to talk about how the jus soli is not the correct. Last time Alito checked, this was America, and we don't just import everything willy-nilly from Great Britain. That was a monarchy. The conditions of subjecthood are quite different than those of citizenship. He talks a lot about allegiance, but what that sort of...
I look forward to him rejecting sovereign immunity in the future.
Woo!
Let's go.
Yes, me too.
Can't sue the king without the king's consent.
Yeah, exactly. Yes.
Yeah.
But if you don't have a king...
Just wanted to point that out. Just throwing that out there.
It's a good thing to point out. But he talks a lot about allegiance. In my mind, the way that this is sort of, just because we don't have a lot of time to go through everything, the main thrust is that it's this monarchy versus consent-based system that the United States has. So
borrowing from John Eastman a lot, actually, right? Like he wrote on that at some point.
Yeah, totally. And also St. George Tucker, I think, suggests he's a wonderful scholar and commentator from the founding era, also suggests that jus soli was not the American rule. So it just makes me think of just to tie it together. Consent being the main difference between the way our polity is set up versus the way that the British one was set up. The consent of the governed is a fundamental aspect of our of the way we do things. And so if you fancy yourself an originalist and a conservative, and you're thinking, hey, it kind of doesn't intuitively make sense that we shouldn't be that allegiance and like pledging yourself to the country and having consent of the actual people and through Congress to allow more people. If you're saying that consent is more important, you're not crazy, because Locke agrees with you. And he talks about subject to the jurisdiction thereof does mean you have an obligation temporarily to while you have tacit consent in a nation to abide by their laws, but it's not until you give your express consent that you actually become part of that nation's body politic. There's a whole thing.
But it's important to note that in the context of our 14th Amendment, the text itself of our 14th Amendment, it does say born in the United States and subject to the jurisdiction thereof.
Yes. So the most I think we can make of this is that we had the original sort of Lockean understanding, and then when by the time the 14th Amendment came, it codified a different understanding.
Yes. Yep. All right, Nathan, give us the lineup scoreboard.
So the Supreme Court says 5-4 is what we're going to call this decision, that the 14th Amendment to the Constitution confers citizenship at birth to everyone born in the United States, and that includes illegal immigrants and temporary visitors, that all those people have citizenship at birth. And then you have the 4 dissenting justices, which I'm going to include Kavanaugh just for simplicity in this, Justice Kavanaugh, and then Justice Gorsuch, Justice Thomas, and Justice Alito.
All right. Thank you for that, Nathan. So, if you have enjoyed our conversation today, please leave us a review and join us next time for more Rightly Decided.